In incorporation of companies, there are so many steps. We will discuss all the steps one by one. First, name availability. Section 4.4 says that application for name availability should be given in form number INC 1 with the fees and with the proposed name of the company. Section 4.2 says that name shall not be identical or it should not resemble to the existing name of any existing company. The name should also not be an offense or it should not be a desirable in the eyes of law. 4.3 says that name shall not be registered if it shows any connection with the government or it's a special word unless such approval from central government is obtained for such special word. 4.5 says that ROC may reserve the name for 60 days from the date of application. So once the name has been approved by the ROC will reserve this name for 60 days, and within 60 days the person will have to file the incorporation paper. The second stage in incorporating a company is to prepare the memorandum of association and article of association. The memorandum of association must contain the following clauses. First is the name clause. The name of the company should be mentioned in the memorandum along with the word private limited or limited as the case may be. Second clause is the state clause. You have to name the state in which registered office of the company is going to be situated. Third clause is the object clause, means the activities which the company wants to pursue. After that, there will be a liability clause. If the company's liability is limited, you have to mention it is a limited liability, limited by share or guarantee, or if it is unlimited, then you have to mention that it is unlimited company. Another clause is capital clause. If the company is having the share capital, this clause you have to mention the structure of share capital, that is the number of shares and the face value of each share. After that, the important clause which has been inserted by New Companies Act 2013 is the nomination clause. This is applicable only in case of one person company, and in this clause you have to give the name of nominee, that is other person, as a nominee in case of one person company. And the last is subscription clause. Apart from memorandum, you also have to draft the articles of association. Article of association contains the general rules and regulations of the company. After the name availability and preparation of memorandum and article, the third step is filing of document with the ROC. Following are the list of documents you have to file with the ROC. First, application for incorporation. It should be in form INC 2. But in case of a one person company, it should be INC 7. Then copy of memorandum and article duly signed by the subscriber should be filed. Declaration from professionals, it should be in INC 8. Affidavit from the subscribers, it should be in INC 9. Verification of address of registered office should be in INC 22. Particulars of subscribers and then particulars of first director along with the consent to act as a director should also be filed. And lastly, the power of attorney should also be filed along with the application for incorporation. Once the ROC is satisfied about the documents, the ROC will issue the certificate of incorporation. ROC will also allot the CIN, that is the corporate identity number. It will be mentioned in the certificate of incorporation. Every company will have to preserve the incorporation documents, that is incorporation paper, till its dissolution. One important question that can be asked in the exam from this chapter is whether the certificate of incorporation is a conclusive evidence that the company exists. So here you have to write that Once the certificate of incorporation is issued, it means that all the requirement of the act has been complied and nobody can question about the existence of the company once the certificate of incorporation has been issued by the ROC. There are two important decided case laws which you can quote in this case is Jubilee Cotton Mills Limited and Musa versus Ibrahim. However, you have to remember that conclusive evidence means that the company exists. It just shows that the company exists. It does not legalize the illegal object as it was decided in Performing Rights Society Limited case. So in this case also you have to write that although certificate of incorporation is a conclusive evidence, but it does not means that whatever illegal objects mentioned in the object clause will become legal. Next is that what will happen if somebody gives the false information at the time of incorporation. So there are provisions mentioned under section 7. 7.5 says the person furnishing the false information will be punishable for fraud under 447. Similarly, the promoter, first directors and person giving declaration at the time of incorporation will also be punishable for fraud under 447. 7.7 says that the power of tribunal. The tribunal may pass following order on the application made to it. So power may include regulation of management, liability of members can be made unlimited. It can order to remove the name of the company from the register, or it can also order the winding up of the company, provided whenever the tribunal will pass such order, it will give the opportunity of being heard and should also consider the transactions already entered by the company and its obligations. Now, one important question that can be asked in the exam is special provision with regard to incorporation of one person company. So these are the main provisions. Subscriber will have to nominate the nominee in form number INC2. Written consent of the nominee will be obtained in INC3. Nominee may withdraw his consent, that is his nomination, by giving a written notice to the sole member as well as to one person company. Remember, these two are different. Sole member and to one person company, he can give the written notice about withdrawal of nomination. Within 15 days of such withdrawal, sole member will nominate another person as nominee after taking a written consent of such another person in INC3 and inform the one person company. Within 30 days of withdrawal of nomination, the company will file form number INC4 with the ROC intimating the withdrawal of consent by old nominee and consent of new. The sole member can also change the nominee in similar fashion by giving the written consent of the new nominee to the one person company. Within 30 days of such change, the one person company will file INC4 to ROC intimating the change of nomination. You have to remember one thing, that any such change in the nomination does not amount to alteration in the memorandum of association. Now, what will happen when the sole member ceases to become a member? It may happen because of the death or incapacity to contract of the member. The nominee will become the member, and within 15 days of such event, the nominee will nominate the other person as nominee after getting a written consent of the another person in INC3, and within 30 days file INC4 to ROC intimating the cessation of membership of sole member and about the new nomination. The word one person company must be mentioned in the brackets below its name wherever its name is painted, affixed or engraved as per section 12. This is another question which can be asked is what are the special provision for incorporating a association not for profit or section 8 companies. So there are rules, rule number 19 and 20 of Companies Incorporation Rules 2014. You have to quote in this case. Rule number 19 says that for any new company as an association for not profit, The application should be made in INC 12. The copy of memorandum of association should be in INC 13. The declaration by professional should be in INC 14. And the special point is that it should also give the estimate of future income for next 3 years along with the sources of income and object of its expenditure. And the declaration by each person making the application should be in INC 15. Rule number 20 covers the extra point for existing company to be converted into section 8 company. So these are the extra points. Rule number 19 के points आपको लिखना है. Apart from this, extra points are copy of last 2 years financial statement, that is director's report, balance sheet, P&L and auditor's report should be submitted. Details of its assets and liabilities should also be given. It should be latest of 30 days information about assets and liabilities. A resolution passed in the meetings of board or general meeting should also be attached. Within a week of making the application, it should publish a public notice in newspaper and also mention in the website. This notice, this public notice should be filed with the ROC in INC 26. After 30 days from the notice, ROC will decide about whether the license should be given to such company or not. And the licenses must be given in the form number INC 16 and INC 17. So these are the important provisions relating to incorporation of non-profit association, section 8 companies. And if you have any doubt, you can ask and call at this number, and don't forget to revise and give the test.